Welcome to the program. My name is Marty Shenkman. I'm joined by my friend and colleague, Alan Gassman, who just got back from a vacation. That's why he looks so abnormally rested. But he still is actually, you're still an estate planner, even though you look so calm and rested, correct?
Frazzled, still frazzled, absolutely.
So we've been doing actually consistently every month since January, a monthly, we call it Estate Planning Magazine, just where we talk about things that we're seeing in practice, some new developments, and just try to give some practical ideas and hash out some thoughts and planning issues that we see in practice. So let me start with one of the things that we talked about just to get it going. So I had a client that came to me who had another practitioner complete an incomplete non-grantor trust, and they were trying to get a non-grantor trust for various income tax planning reasons. What are your feelings about using an ing structure versus more of a maybe a simpler, more direct structure like a slant, a spousal lifetime access non-grantor trust, where you just give an adverse party the requirement to approve any distributions to the spouse? Any thoughts on that? How do you
Well,
feel about it?
the human tendency to want to be able to control and take back is what fuels the ing demand because this is a trust that I set up that is a separate income tax entity. It's not subject to state income taxes, yet I get it back eventually. So with the slant or something like that, you don't really get it back, right? It has to be a complete gift.
It has to be a completed gift. I have a whole bunch of thoughts, and I'm in no way saying you shouldn't do it or it doesn't work. I'm not implying that at all. I don't want to in any way, you know, suggest that what practitioners are doing isn't right. I don't. I never wanted to be that guy. But to me, there's a whole bunch of thoughts. First, the IRS used to issue rulings. So one of the positive, still positive aspects of it is there's like a lot of rulings out there saying how to do it. But it concerned me when the IRS, I think a few years ago, said we're not going to issue rulings anymore. And as I recall, there was a law review article by a professor that pointed out why he felt that Ings didn't work. And it was just his opinion. But I think I thought, I don't remember the details, that that's why the IRS backed off from issuing further rulings on Ings. So if they're not going to issue rulings and they used to issue rulings, maybe it's a thought that you may want to try a different structure. And if you have just an arrangement where you have an adverse party approve distributions to a spouse and you structure it with all the exclusions of all the powers that could taint it as grantor, that may be another approach at least worth pondering. Another thought that I had on Ings is right now we have $15 million permanent so-called exemptions, which may not very well be permanent. But it just strikes me that if the client still has as a couple $30 million of exemption or an individual 15 million of exemption, before I did an incomplete non-grantor trust, assuming we need non-grantor trust structures, I probably want to do a completed gift one and use up my exemption just because I don't know what's going to happen next in Washington. So
That's right.
that's another thought. And in terms of state tax, I believe New York was the first. I think California joined. I'm not aware of any other states that have said they won't respect INGs. And if you do a non-grantor trust that's structured as an incomplete gift, they're going to treat it as a grantor trust and subject you to New York or California, as the case may be, income tax. So if you have a client living in New York or California, I'd want to carefully evaluate, can I somehow use a completed gift non-grantor trust so I get the state income tax savings as well? That was just another thought. Um, what about the adverse party? What do you think it takes to be an adverse party? Do you see any, have you seen any issues with that? And I'll
Well, it
comment when you're
needs
done.
it needs to be a beneficiary who gets hurt if there's a distribution to the spouse, right? That that's an adverse party. Or an adverse party is a party where you run out of liquor in the middle of the party.
You have to have, I think, a substantial material economic interest that's adverse. It can't be ephemeral. It can't be just, you know, something that's not relevant. One of the issues that I've seen, I'm curious if you've seen it, is when the kids that are beneficiaries are minors. Have you addressed that or dealt with that?
No, I haven't thought about that. So you need approval of an adverse party, and the adverse party is the only adverse parties are minors.
Right.
Do you?
So
I've never seen a clause for that to say that that would be exercisable in favor of their parent or anything like that. That's a good.
I've seen where people have used um, a grandparent who would act on behalf of the minor until they turn adult. I mean, what I like about that is that the kid clearly has an adverse interest, and you have somebody who is in a responsible position. It's not a guardian. Do they have the legal authority? Can they really exercise the power on behalf of a minor to negate it? If a court looked at it, wouldn't they want the minor to get all the money?
Yeah,
So,
I mean, yeah, you would breach your fiduciary duty
right.
to consent on behalf of a minor.
So
But
I,
like I
I,
said, you don't need consent of an adverse party. You just need an adverse party. So the minor's fine if you don't want to make a distribution.
but if you make a distribution, then you're having somebody else act on their behalf. It raises questions. But I've seen that issue come up. I saw one that had a different structure where the adverse party, what they did is the settlor's college roommate, my guess, I don't know if he was actually a college roommate, but we'll call him maybe in a law school roommate, call him a college roommate, was given a 5% interest in the trust. And then because of that, they felt that this person was adverse, and then they could approve distributions to the spouse. How do you feel about that?
It sounds okay with me as long as 5% would be enough. I would think 5% would be enough because if you had 20 children, each one would have 5%, right?
I think 5% is material.
Yeah.
Here's what concerned me with that. So let's take it a couple steps further. The college roommate, the spouse was given a limited power of appointment that she could exercise to appoint to descendants. So if she signs a will within a reasonable time frame of this ing being created, it and appoints all the assets to just the kids, is that really a real adverse interest?
Yeah. It's a good question. I would think technically it is because I don't think there's ever read a case or a commentary that says that it wouldn't be. But you bring up a good point. So you could put an adverse party in and take them out the next day by the stroke of a pen, although they could be put back in if the will got replaced, right?
Yeah, I would be concerned about that because I think now it starts to look like they never really had a real interest. It was never a real material or substantial interest. You just used this arrangement with the sort of preconceived notion that you're going to remove them because you never really wanted them to get anything, and they probably had an implied agreement they weren't going to get anything, and you took them out. That worries me. Um, so I think we've just covered a whole bunch of interesting little nuances with INGs and non-grantor trust generally. There's been a lot of talk of non-grantor trusts, especially post-OBA with 199A and so on and so forth, SALT deductions and charitable deductions. So I just thought that was kind of timely and interesting. So let's change gears completely. And I asked you ahead of time to be fair, and I'm going to use you as a guinea pig. You didn't know that. If you had read and were familiar with IRS Alert 2026-19 on AI. So I'll just tell you in a nutshell a little bit of what it does. And then I'm going to ask you a question because you're going to prove my concern about this IRS alert. The IRS is obviously and reasonably concerned that, you know, you don't want taxpayers, certainly you don't want advisors just asking questions to AI and getting half-baked answers and taking positions on returns that are just completely wrong. So the IRS has come out and said, you know, if you use AI, you have to like research it, make sure it's right. You have to check citations. You can't just have AI say, yes, Alan's barber fees to his barber are deductible. He got to have something more substantive. And I think that makes sense. The alert really importantly points out, because we keep seeing cases after cases, is yes, AI hallucinates, and yes, you got to check citations, and no, you can't just upload client information into a free consumer AI portal, because you're destroying confidentiality and privilege. And you and I have written and talked about that. The Hepner case, I think, was one of the issues, one of the cases. But one of the things that this ruling does, and we're going to be brief because it's worthy of its own entire webinar. If you look back at the ABA model rules, I think they were very reasoned, no pun intended, you'll see, in what the standards were that the ABA applied to practitioners, that you have to take reasonable precautions and reasonable steps, because everything is kind of, depends on the amount involved. If it's immaterial, you could do less than if it's a huge number or a very sensitive issue. So there's really a pervasive, as I see it, reasonableness standard in the ABA ethics rules on technology and cybersecurity and AI. What the IRS alert did, and again, the number was 2026-19, it seems to have used in a very limited way a reasonableness standard, but it seems to have required much more, at least the way I read it. It seems to require that practitioners understand how the AI large language models work. It seems to require you to understand some of the technology. It seems to require that you have robust security and that you have thorough review. What worries me about that is reasonable review. Okay, we can look at community standards of how, practitioners practice, what's reasonable in the circumstances. But thorough review, is that even reasonable? It seems to be beyond reasonable. I'm not sure how, where, why they came up with some of the terminology. I think the goals make sense. Providing guidance makes sense, but a lot of the terminology is worrisome. And the level of training that they suggest seems impossible to meet. So you're actively involved in the creation and growing of EstateView, which is an AI-based estate planning software program. Do you understand the technology behind all this stuff?
No, I know how to
Then
use
why would you?
it. No. Mm-mm.
Okay, so you're my case study to prove that you can't, if you are doing as much as you're doing more than probably any practitioner I know anywhere, probably more than most firms combined are. If you know, and why would you need to understand the mechanics? I think what the rationale behind the ABA concepts are is, listen, we got full-time jobs and lots of responsibility to keep current in our area of the law. You can't possibly be an engineer and a technician and an IT consultant on top of all that for most practitioners. And maybe there's a few guys that can, but I just don't think so. So I'm not sure where this is going to go, but I think it affects anyone who prepares or reviews a gift tax, estate tax, trust income tax return. I think everybody needs to be mindful of this. And I think the standards are worrisome. I don't know what the practical answer is, but I think everyone needs to look into this and see what positions they want to take in their firm. So, any other thoughts or comments, or I want to go
Oh, I think you
one.
covered that well. Anything that comes from AI, you've got to double check and triple check. There's no doubt about it.
Well, can I disagree with you on this? I think it depends. I really think the ABA nailed it with applying reasonable standards based on materiality, this, that, and the other thing. You're filing a gift tax return where there's $100 million note sale, and you're not sure if the particular crummy power works. It's 19 grand. How material is that to the return? How much time do you really need to spend to see if the hanging power this or that, or if it's a gift of an interest in an FLP, if it's really meets the requirement of a present interest? I mean, how far are you going to go when it's inconsequential, immaterial compared to the whole return? But I'll give you another example that I haven't seen talked about, but I think is very important. And to me, it's actually a great use of AI if it's done carefully, that I think gives better service and less costly service to clients. So I had a client that had a question. They have a vacation home in state X and they live in state Y. And the client told me, I'm taking care of it. I know what to do. I'm going to do such and such with the vacation home. I solved my problem. Didn't sound right to me. Didn't seem like it was really a detailed analysis. But having done this for 40 years, I think I kind of knew how to ask the questions of AI a lot better than a layperson, for sure. And I asked AI some questions. The client didn't want to authorize me to do much work. I spent 15 minutes with it. And what I did is the memo that I sent the client, I attached an appendix. And I said, the following are some considerations based on preliminary, not reviewed, and I put it in caps and bold, and I think I even yellow highlighted, not reviewed, not corroborated. You can't take it as advice. AI research. And the purpose was to say to the client, listen, you said you're doing it, you don't want me involved. Okay. I can't really spend a lot of time and do the job right, but take a look at some of these thoughts because there's a lot more to this than whatever you were told or read or heard. So to me, I think that's a good use of AI because what I'm trying to do is motivate the client to really properly address something. If I said to the client, I'm going to need 3 hours to take a preliminary look at this properly, they would never authorize it. So I think the degree of review depends on what you're doing with it. And I also think, as a caution to colleagues, if you're going to use AI as sort of a preliminary discussion point, you got to say, hey, not review, preliminary discussion, don't do anything. But I think that's a valid use of it because it's not a layperson asking the question, it's an experienced practitioner that probably is getting reasonable, not foolproof by any means. We know about hallucinations and everything else. Thoughts, comments?
I think you're absolutely right. As long as you're transparent with the client that you can't verify whether this is correct or not, but it's a start, I think that's great because, as you know, 90% of the time it is correct, or maybe 85% of the time it is correct. So you've done the client a favor as long as it's very clear that they're not to rely on it. I don't
Yeah,
think the CPA is telling you not, you can't do that type of thing. They're just telling you not to rely on it. I mean, the IRS is telling you don't rely on that in tax reporting, right?
tax reporting, I would never permit something like that to be
Right.
filed, a position based on that. What I was trying to do is motivate the client to take action. And I'll give you another example. So, on a particular client matter, and this is not uncommon, we had a dozen documents. And I'm trying to figure out how much of an LLC the client owns versus a trust that they had made some transfers with prior counsel to. For for even a junior associate, because it could be done at a junior associate level, look at every document, look at any time in the document or an attachment or tax return. They gave us some tax returns, assignments. Look at every single document and list out the percentage interests in this LLC because I want to make sure it's correct. It would take some time for even and cost for even a junior person to go through, you know, 20 different documents. But I said to AI on the Jane Smith file, I'd like you to review every document in that file and identify what's stated as to the membership interests owned by different parties and just give me a summary, name of the document, where you found it, the percentage, and what the document said happened. And the client, if I said I'm going to need to have somebody, it's going to be a couple of days of work to go through all this stuff, the client's going to say no in many cases. They don't want to incur the cost. But if I said to the client, listen, it'll take me 20 minutes to get AI to take the look at it and 30 minutes to review it, about an hour at a time, it's not going to be perfect. And we're not having a human being verify it. So there is risk. And an example of the risk is you have a copy of a copy of a copy that was scanned and the AI can't read it, but a human eye might have. But nonetheless, for a very modest amount of time by comparison, I have an analysis that helps me point out any inconsistencies in the membership interest that I'm concerned about in their gift tax reporting. It seems to me that there are uses of AI if the client is accepting and I determine professionally that it's a reasonable application. Thoughts or comments?
I think that's a fantastic use of AI because, first of all, it's really good at what you just described. It's really good at going through 20 documents and telling you that there is to know about who owns what in these. And then a young lawyer or even a paralegal can go and tab the pages that led to that conclusion. And then you can spend 35 minutes instead of 3.5 hours verifying it. That's
Yeah, so
perfect.
that's I think what we just discussed is what worries me about this IRS alert and some of the statements people are making. I think it really comes back to, and I'm going to sound like generic ABA stuff, but I agree with the view. You got to do what's reasonable. You got to use professional judgment. But if you unduly limit what you can use, how you can use AI by saying emphatically across the board, you have to review every single thing AI does, you're really limiting how this tool can be used to help clients. If you professionally determine that something is not material, why should you have to bill X number of hours if you can do it for 1/10 of that? If you want to get the lay of the land to help raise a question, why can't you do it? I think it's really critical that we as practitioners make it very clear to the client what we've done and not done so there's no ambiguity and they can't go make a decision based on something that's imperfect.
The other thing in your example is if there was a mistake, AI almost always would have found it. And then aha, there's a mistake. Here it is right here. So the fact that AI did not find the mistake, that's pretty good. That's very helpful. Let's put it that way.
In the case that I just described, it was actually a matrimonial matter, and I was asked to review some trust matters on it. And just one of the things, and I kind of tinkered and experimented and asked AI to go through all these documents because I knew the client wouldn't pay for it. And it found some inconsistencies in how the ex-spouse had handled the transfers, which was quite helpful.
Yeah, in common.
In common. So let's change gears. Here's another thing that came up. And we kind of talked about this, and I chuckled when you said that's exactly what they did. But let's talk about it. So there was a multi-member LLC that was taxed as a partnership, and mom bought out the third party, unrelated party who owned 5 or 10% of the partnership of the LLC. And then 6 months later, the accountant said, "Gee golly, you're no longer a partnership because you only got one person. Now you're a disregarded entity." So corporate counsel recommended, and then I'll let you dissect it. And if you leave any openings, I'll answer. But corporate counsel suggested, well, give the kid, one of the kids, a 1% profits interest in the partnership because that won't create any gift tax cost. There's actually more than 1%, call it 10%. And that'll now create a multi-member partnership, so it's taxed as a partnership. And then corporate counsel said, well, just make the date of that effective, the date that the third party was bought out, so you never lose partnership tax status. Comments and thoughts?
Well, it was a good idea, and maybe the accountant was naive enough to think that it's okay to backdate in situations like that. But it's not
Isn't backdate a 4-letter word?
for backdate is worse than that. It's an 8-letter word. It's 2 4-letter words, twice as bad. But yeah, I mean, people do it. There's no harm to the Internal Revenue Service. It's the same tax result, probably, unless the child is in a lower bracket and 1% makes a difference. But it's just something that we don't want to do.
I think if something like that, first of all, you don't want to do it, and practitioners never want to be involved with that because it's problematic. If you did it, which I'm not saying you do, make sure it's signed currently and then explain why somewhere you've done it and what the tax consequences. The other issue is how sure can you be that a profits interest is not got a value for gift tax purposes?
Yeah, it would have a value. You would hope it would be under the $19,000 amount, but that's a good point also.
You need to have somebody tell you what it's worth if you want to take that position.
Yeah. Or use a formula clause to say I'm only giving a profits interest. It's reduced proportionally to the extent necessary to be a $19,000 transfer.
It's yeah. I think what happens so often in practice is there's a problem. Somebody wants to come up with a simple and inexpensive and quick solution, and they don't really want to bother thinking through all the ramifications because they just want to get it done. But that's the kind of stuff that can really trip people up and cause problems later. So let's change gears. So one of the things that's common, certainly in community property states, but I actually see it commonly in non-community property states, are joint revocable trusts. And one of the issues that I have with joint revocable trusts in non-community property states is a lot of the practitioners doing these think that they get a full basis step up on the first death, but they don't. And I, with no jest intended, suggest to them that they could use your technique of giving a general power. And there's pros and cons and issues and discussions, but at least at least you're giving an argument as to why there should be a full basis step up. A pure, typical, standard joint revocable trust in a non-community property state just doesn't work. One of the places I've seen issues with joint revocable trusts in community or non-community property states is when gifts are made. And a lot of times I think that the longer way is the safer or better way. Because if you make a gift out of a joint revocable trust, whose property is it? Sometimes they'll have like a schedule of the husband's property, a schedule of the wife's property, a schedule of joint or community property, all the above. There could be multiple schedules. If you're not careful, who's really making the gift and whose asset is it? That concerns me. I prefer, even though it's an extra step, unless there's like a realty transfer tax or something that's going to be triggered or a due on transfer clause, but you're transferring it anyhow, is to get the asset out of the joint revocable trust to the spouse who's going to make the gift. Forgive me. And then excuse me, I'm sorry. And then let them make the gift. Any thoughts or comments on that?
That's certainly going to be cleaner, and it's not a big deal to pull it out of the joint trust and let them make a
Oh,
gift. Let me mention, there is the joint exempt step up trust, which is designed to allow a full step up on the first death. Also, some states, including Virginia and Tennessee, have a joint trust statute that allows the joint trust to be considered a tenancy by the entirety's asset for creditor protection purposes, and also allows on the first death the trust assets up to 15 million worth to be set up into a credit shelter trust
wow.
and benefit the surviving spouse. So there
Which
are
states are those?
it includes Virginia, Tennessee, and I think North Carolina. There's 7 or 8 of them. Florida has
Oh,
not adopted it yet. But for clients in those states, we have used joint trusts. Or when people are just don't have a lot and it's complicated enough for them to have each a revocable trust, a joint trust. But there
I think that's one of the common comments I've heard from practitioners who do it. Like when I ask, like, why do you do it? Because one of the things I don't like about it is now are all the assets in the same bucket if there's a creditor claim, and the answer may be yes. But they say clients like it. It's simple. The estate's not big. That kind of makes sense. I see where they continue to do it as the estates get bigger, and then they run into this sort of nettlesome uh, issue of whose property is it when you're making a gift. And that's why I prefer that if you start to get larger estates, do you really want to join trust if you're not in a community property state? If you're doing it for basis step up, use an opt-in community property trust, which a number of states permit, or use a just so at least you have an argument that it gets a full step up. But when you're making gifts, you got to be very methodical to know which schedule the property comes from. You probably want to go back and make sure that when the property came into the trust, it was properly characterized because that's important. But I prefer just to play it safe and get the property out of the revocable trust. If it's in community property, I'd like to see a transmutation agreement so it's clear that it's not community property no longer. Let's say wife gave up her interest, so it's husband's property, it's in his name, it's been transmuted, now he makes the gift. a few more steps, but I think especially if the dollars are important or creditor protection is important, it's good to be clear and precise on what you've done.
Right.
Um, so I'm not really prepared to talk in great detail, but I think it's important. So let me just mention there was a lot of talk at a lot of conferences about the McDougall case and whether when you terminated a marital trust and the assets went to the spouse, did the kids as remainder beneficiaries make a gift? And the answer was yes. But then the question became, how do you value that gift? And I think a lot of us said, like, when you have like powers of appointment and things are uncertain, you don't know how much is going to be drawn out. How do you value a gift like that? And that was the question. And it was just decided the case, instead of being under McDougall, comes under Linda M. Lewis, petitioner versus commissioner, because she was the other sibling. TC Memo 2026-58. So it just came out, and it sounds like you have a gift, and you're going to value the gift under state law, not using the actuarial tables. They seem to apply a concept of like a net gift, so that if there's a 40% tax rate and if there was a gift, the kids would have to pay the tax, so that you would reduce proportionally. Like if it's if it's a $10 million gift, divide by 1.4, because 40% is the gift tax, state tax rate, and you got a haircut on that. But they taxed it as a full value based on that. So I think the lesson from the conclusion, if you will, of the McDougall case, I don't think it's going to go further, but we'll see, is that you have to be very much more careful than we may have thought if you're doing a termination of a QTIP trust. It's not just doing a 2519 analysis that you have a gift on termination from that. It's really the analysis under this case. And I think any kind of decanting or non-judicial modification, we need to really more carefully evaluate what the potential gift tax consequences are of somebody making a gift.
And put trust protectors in your documents so that they can allow these things to happen, so you don't need consent from the next generation that would be considered to be making a gift.
Yeah, I would probably name them something other than trust protector, because sometimes people have trust protectors and some state laws require trust protectors to act with a fiduciary duty. You want this power to be held in a non-fiduciary capacity, or if state law permits, expressly say that the trust protector shall act without any fiduciary obligations. But that's a good point. We're going to all have to analyze this, because I think this could be a game changer on a lot of the transactions that we've all kind of done. Um, so let me go to a couple of practical things that I've seen come up lately that I know everyone sees. They're not very technical, but I just think they're important to talk about because they do come up. So I had a situation recently where a parent unfortunately felt they had a disinherited child, and we had a conversation, which was not an easy one. And I discussed with the client, not all clients are willing to have this discussion. Listen, it's really to say, you get nothing and you are disinherited is very harsh. Why don't you set up a separate irrevocable life insurance trust, not a big deal, to a simple home state trust, and have some of the insurance policies you own transferred by sale to that trust to avoid the 3-year rule. But this way, when you pass, the kid has first, there's money in the trust, and we do an interim or no contest clause that covers not just the will, but any trust, including the ILIT, so that the kid now has some loss if they want to challenge and make grief for everybody else. But also by leaving the child something meaningful, maybe not anywhere near what the other kids are getting, it takes some of the sting out of a disinheritance. You haven't been fully disinherited. You're just not under the will because, you know what, there's too much antagonism. We don't want to involve you. I've provided for you separately. And I like the idea of an ILIT, because then the kid can be cleanly disinherited, but gets their inheritance under another instrument, so that you're trying to minimize the potential for conflict with the remaining family. Thoughts, comments?
I think that's a great idea. And if it's a term policy and they don't want the child to inherit later because it gets even worse, they can stop paying the premiums. And by having that child not be a beneficiary of the revocable trust, the child has no right to see the revocable trust and doesn't have a seat at the table relating to the revocable trust, but is saving face because people who read the revocable trust says, well, my son John is handled elsewhere,
Yes.
opposed to my son John is a piece of garbage and I leave him nothing. It just says my son John is handled by this separate trust, and then it's up to John if he wants to share the situation. I hope you told the clients that they're not the only ones doing this. Our clients seem to don't understand that there's a high estrangement rate with children,
It's
and
sadly not unusual at all.
but it's lots of families have estrangement, almost.
I just feel emotionally there's a huge difference between leaving something that's meaningful, even if it's a tiny fraction of what everyone else is getting, and doing it using exactly as you said. Don't put in the ugly language. And I tell clients, listen, what if you reconcile on your deathbed? Would you want to have that harsh language? Wouldn't it be better just to have left something in another way? And those are hard conversations, but I think it's an effective way to do it. And you want to minimize the potential for conflict. Like you said, if the kid is disinherited expressly under the will or rev trust, then they don't have a seat at that table. But there's
Right.
also something else to take the sting out of it. And I don't know, I've always heard, well, gee, if they're getting X dollars and there's a no contest clause, they have something to lose. I don't know if the money, if somebody's angry enough, is going to dissuade them from challenging something. But I think the planning where you've expressly shown that you thought about them, you've left them something, they're expressly not included under the primary documents is a good way to go.
Yeah. It's also not a bad idea to put in that trust that they only inherit if they don't raise Cain elsewhere,
Yes.
and that a trust protector could eliminate them in favor of the other children. So then if the child becomes Godzilla and starts suing everybody, they won't get anything from that life
Eh,
insurance trust.
What about just giving like the surviving spouse a limited power of appointment?
That
Point it
works.
away.
The real question is whether the child's going to litigate after the surviving spouse dies.
Yeah. Well, that's why you could have a trust protector too, or
Yeah.
somebody else hold the power.
Yeah.
I've
Yeah.
never done it and just thought of it. I mean, the SPAT, special power of appointment trust concept, like Blottmacher has talked about, that may be interesting in that context too, because it's a way to, if they make hay, to allocate away from them. Um, so I had another thought and I lost it, so I'm going to go to another one. Um, One of the things that I've seen, and we just actually had a situation like this that we're still working on. Um, Parents often help kids get houses, but if you have expensive homes that are being bought, you can't always just make a gift because if they've used their exemption up on other planning, what do you do? What we've done in some cases is actually had the houses sold for notes to a slat or other type of grant or trust. So we get them out of the parent's estate, freeze the value. But then the question becomes, how do you get, when this happens after the trusts were set up, how do you get the right house to the right kid? So we have a situation where one kid's house is worth 5 million, another's worth 5 million, another's worth 20 million. How do we equalize? What do we do? And one of the concerns is, how can a trustee get comfortable making a disproportionate distribution? I think a trustee would understand that if each of the kids has a $5 million house and the trust is divided into three on the second parent's death, you give each kid their house. But how do you make up the difference? And because of the wide difference here, I was very concerned with what could happen. And we could even make distributions of the houses today while the parents are alive if we chose to. But again, you have a disparity in the values of the house. So one of the things that I was thinking about, except now I'm concerned with the Lewis McDougall gift issue, is what if we did a non-judicial modification? Because I want the trustees to be committed to making a distribution to each kid of their house. And by doing a non-judicial modification, I'm not controlling the trust so much as saying everybody agrees to that's how it's distributed. But I think now you have a gift issue potentially under Lewis/McDougall.
Hmm. So you appoint trust protectors under the trust and let them do it a couple of years later and do a letter of intent saying, I've appointed my friends Marty and John to be the trust protectors, and I request but do not require that after my death, they should do this and that and the other thing. And
You're not
that way you don't have the children doing it. You just Uncle Joe handles it after they die. That's one
so
solution.
that's really like a limited power of appointment held by somebody in a non-fiduciary capacity to appoint just the houses
Right.
or whatever else you choose to have them do.
Right. So the children just have to approve the appointment of the trust protectors, which is not a gift that I can think of. And then later on, this coincidentally happens. That would be one way to handle it.
One of the reasons I wish I could do and prefer to do if I can, but I'm concerned now about the gift issue in light of this case, is I'd like the kids to agree in writing that this is how things are being divvied up. Because if they don't agree in writing, I could see the kids, and I'll just use the same hypothetical numbers. Two kids are getting $5 million houses and one's getting, I think I said 20. I forgot what the number I made up was. But I don't want the kids getting the lesser value houses to be feeling that, whoever's acting is not acting consistent with what they think parents wanted because why are they not getting equalized? And I don't want them running around and being angry and destroying the family over this. Any thoughts on that?
No, I think you're sound, but I mean, are you going to have the client's revocable trust and the rest of their assets even up to take this into account?
We're,
Because
we're still we're
are
still
off the top.
we're still figuring it out. I don't know.
Yeah,
But I do know that I want all this resolved, however it's resolved, while mom and dad are alive, because
right.
I shudder to think what the emotions will be for the kids with disparate distributions if mom and dad didn't somehow sit them down and say, "This is what's happening. Don't complain."
By the way, if you want to cause a fight among the in-laws and siblings among your children, give one a bigger house than the other. That's a great way to
That's what I'm trying not to do.
ever. Why does that child need a $20 million home? Why don't I have a $20 million home?
It's funny you said that. Some of the worst fights that I've seen in all my 40 years are over exactly this issue. Johnny got the bigger house.
Yep, yep. So
Yeah,
that's
it
it.
becomes very emotional.
Yep, absolutely.
So, anything you have going on you want to talk about?
Well, we talked about the desire of certain advisors and very smart people to keep everything simple.
Yes, that was my last
And
topic.
we get that all the time. And one of my mentors used to call clients in, and I'd have this big complicated chart on the table, which I always do. And he says, for every complicated situation, there is a simple solution in estate planning. The problem is it's the wrong solution. Complicated situations call for complicated multi-structure solutions. And usually the advisor who's calling for all this simplicity is the advisor who doesn't understand all
Yes.
of these solutions. So, and then we live with this later. I'm living with one right now where a very, very bright man wanted everything simple. He didn't want trusts. So he just set up family limited partnerships, and his kids are all member partners of these partnerships. And now you can't disinherit a child who, is a mess. You're just stuck with that child as a partner. And he kept it simple. So it's a simple mess, is what it is. So what are your thoughts on all that?
So let me give an example of something that just happened. And let me tell you about an article I just wrote, which I did with a psychologist that I thought was quite interesting. Um, so I had a prospective client call me, email me, right, who uses the phone anymore, and tells me, and it was like way too much information, TMI, too much information. I mean, he hasn't hired me yet. Like, why are you giving me all this information? But I got the email. What am I going to do? So in the email, he explains that it's a second marriage. They both have kids from prior marriages. They have one kid that's fabulously wealthy, self-made tech entrepreneur and like out of the league of everybody else. So you have huge wealth disparity between the kids, big age disparity. They have kids from the new marriage, so huge age disparities. One of the kids has an addiction issue. Another kid has special needs. And I mentioned second marriage. Their estate was, let's say, 20 million. They live in a state that's decoupled that only has, a couple $1 million exemption. So you got state estate tax. And then he concluded the email. Oh, and he has asset protection worries because of the nature of his business. And he concluded the email. All he wants is a simple plan. So I kind of emailed him back and said, listen, sort of explained the facts and what they mean. I said, I don't know how you do a simple plan when your facts are so complicated. And unlike many of the people who just get upset because yeah, they told me you lawyers would always want to make it complicated so you could bill me more. He actually pondered it and said, you're right. My circumstances are pretty complicated. I guess I can't get a simple plan. That was one of the few self-aware people. Anyhow, I like probably everyone gets frustrated with this obsession, and I really think it's like an obsession with simplicity. And I just wrote an article. I forgot which journal we sent it to with a psychologist and I asked him about this concept of simple. And he said what he suggested start off by, and I don't remember the psychological terms, but like, making nice to the client, not his words, by saying, yeah, everybody wants simple, which I think is true. So I understand that you want simple. Everybody wants simple. And he suggested setting it up as a trade off. We could do simple but I'd like to at least explain to you the consequences of what simple means. So let's take an example. I'll use the one you just gave, Alan. You don't want trust because you view trust as complicated. Okay. But if you leave everything outright to your children and one of your children gets divorced, we all know that the divorce rate is whichever numbers you're using, it's still pretty high. That those assets are going to be in their name and if they've been commingled, which is it's almost like a physics principle where assets have to get commingled, right? You can't possibly get a gift or an inheritance and not commingle it. It's like some physics principle where it has to get commingled. They're going to lose potentially half of those assets. So outright is simple, but are you concerned about divorce? And to go through and show them the consequences is simple. And if they're comfortable and agreeable to accept the consequences, then you do it for them. You've protected yourself. You've done the right thing for the client explaining it. But he felt that if you actually, instead of saying no, simple doesn't work because now you're being, putting them on the defensive or saying they're wrong, rather say that's fine. We can do simple. Everybody wants simple, which is pretty much the case. But let me just go through some of the consequences of that decision. And as long as you're comfortable, we can do it.
Right, right. Well, I mean, even Einstein said, "Be as simple as possible, but not more simple than necessary." Now, another one of my heroes, and probably yours too, Howard Zuritsky, used to always say, "Never have
Now
the."
I'm envisioning him in like red tights and a cape.
Howard Howard said, "Never put your client into a structure that the client cannot explain to you at a cocktail party." And I think that that's a little bit, I mean, I've got a lot of clients in structures that they would not be able to explain at a cocktail party, probably because my clients drink a lot. And after three drinks, they can't. But I think you do have to make sure that the client does understand the structure, or at least the CPA, the financial planner, the spouse, people who care understand the structure at the time the structure is put into place. So I think we can spend more time explaining the structure if I had known that client better when he set up his family limited partnerships, if I hadn't been a 26-year-old lawyer and he was a 55-year-old surgeon, I may have been able to convince him to do those trusts, but I wasn't able to as a 26-year-old lawyer, and I'm living with it now as a 67-year-old lawyer. So just we all do what we can, and the degree of simplicity versus complexity is just part of the art and the science of what we do.
My wife is an anesthesiologist, and I was talking to her about this simple concept once. She said, and she taught me something very important. When you have a really bad headache, two Tylenol, I'm sorry, two Advil and one Tylenol, because they work on pain differently.
Hmm.
I said, oh, remember that, Alan. That's very valuable. But I
Yeah.
said, what do they do different? And she has explained it to me at least 10 times. I don't get it, but I do know that two Advil and a Tylenol really can do a number on a headache. I mean, clients accept complexity in all sorts of things. You can't get under the hood of a typical car now unless you're a computer technician, right? I mean, it's not enough to be, to know something about car mechanics. You got to know technology. So people accept complexity in everything. I mean, our smartphones, they may be simple. You push a button, but what's going on behind that button you pushed is incredibly complex, just like the AI stuff. So I think a lot of the simplicity is misguided, but then we still have the issue of dealing with the psychology of clients, which, I find it's hard because there's so much complexity that we as practitioners have to keep track of. To now deal with the psychology of how to explain it to clients it's just daunting. But I think the concept, and I'm going to try it going forward, since now I wrote this article with the psychologist. Yeah, everybody wants simple. Just let me explain some of the consequences. And if you're comfortable, that's fine. That's what we'll do.
Yeah. Marty, can we just talk a minute about the Notre Dame Institute and why
Sure.
it's different? So, Jerry Hash, who is another superhero in our industry, both academically and professionally, is the
And
direct
a nice guy.
and a fantastic man who cares about everyone who's ever been his student. And by the way, everyone has been his student. Runs this conference in an extremely conscientious manner because not only does he come up with interesting topics or hybrids of
Practical.
practical
Practical.
topics, he searches far and wide and does a lot of due diligence on speakers. And then he can be a blessing and a curse because when you speak for Jerry, he wants a quality white paper and he tells you what to make sure to cover and he gives you a full 60 minutes. And the difference between a 50-minute talk and a 60-minute talk is huge.
And a lot of institutes are 45 minutes. You
A
just
lot
can't
of it
get points
for
across.
45 minutes. The speakers have plenty of time to prepare, and then he arranges the topics so that there's synergism between the topics. So if you've never gone to the Notre Dame Tax Institute or purchased the tapes, it is, I think, overall the highest quality. And this year it is on the campus of Notre Dame University
Which is neat.
campus, which is very neat. And it's limited in size. I think he can only take about 150 people. So, and it's a very friendly Northwestern crowd. So if you've never been to the Notre Dame Tax Institute, I would definitely give this one a try. I've had clients go who know nothing about tax and estate planning and come out after 2.5 days and say, wow, I don't know what I learned, but I learned a lot. So whether you're a top-notch practitioner or somebody just getting into the industry, I think it's the best educational experience in our industry that you can find, and it's only once a year for 2.5 days.
Okay, sounds good. I will see hopefully lots of you there. You will get the joy of hearing Alan and I speak on Wednesday. I went to the Institute for years because when I first discovered it, I thought it was one of the most practical estate and tax planning programs. And it also he gets topics that are a little more on the fringe, relevant and practical, but it broadens it's not like, the same topics you've heard 15 times. A lot of times there's new topics, which is really helpful to expand your professional knowledge and perspectives on things. Alan, I think we're pretty much out of time. I thank you for doing this yet again for another month. I thought it was interesting. We welcome any comments, feedback, input. We're trying to do this as an informal discussion and talk about things that we see in practice that are real, sometimes new developments, sometimes less technical. But I think that's all important to help us all practice better. Alan,
Uh,
any final words?
no, thanks for your leadership, and I hope everybody has a fantastic rest of their month.
Take care, everybody.